members of the public in matters relating to, ancillary or incidental to the law, as well as uphold the Constitution of Kenya and advance the rule of law and the administration of justice. We have in the recent past witnessed events which portend a grave danger to the rule of law and the administration of justice, and which must be addressed immediately if we are to maintain faith in our institutions. The Office of the Director of Public Prosecutions under Article 157 of the Constitution is an independent office and exercises the power to prosecute on behalf of the public. In exercising his powers, the DPP shall have regard to public interest, the interest of the administration of justice, and prevent and avoid abuse of the legal process. We have witnessed a spate of withdrawal of cases facing various suspects, and some of whom have been nominated for appointment as cabinet secretaries. The profile of the suspects invites significant public interest as to the motive of the discontinuation of the cases, and further poses serious credibility concerns in the investigative capacity of our institutions. The Law Society of Kenya is alive to the fact that before any prosecution is commenced, the DPP reviews the file under the decision to charge guidelines and only approve the charges if the investigations reveal a probable case against the suspects. This is a sacrosanct duty that the Constitution placed upon the office of the DPP to ensure that the public interest is protected and the criminal process is not used for other motives. We are therefore alarmed by the recent decisions by the DPP, as they point to either two very disturbing scenarios. One, that the prosecutions were mounted for ulterior purposes whose end have been achieved or overtaken by events, or two, that the DPP has withdrawn the cases to aid an ulterior motive. The Director of Public Prosecution therefore owes the country an explanation as to the reason informing the discontinuation of cases. If the cases are being withdrawn for lack of evidence to sustain the charges, the DPP must take responsibility and explain how the decision to charge was arrived at in the first instance. We all recall that some of those suspects were arrested in somewhat dramatic situations, with media press releases as to the reasons for their arrest and arraignment in court. However, the discontinuation of charges have been done silently and without any press release from the DPP. The Law Society is also aware of the frosty relationships between the former Director of Criminal Investigations and the DPP, as well as the sustained efforts by the DCI to prosecute cases without the consent of the DPP. The Society therefore calls on the DPP to publicly reveal the reasons for the discontinuation of the cases if the public are to restore confidence in the office of the Director of Public Prosecutions. We similarly call on the judiciary, and especially the magistrates handling the cases, to insist on the DPP providing credible and cogent reasons before allowing the discontinuation of the charges. This is to assert the independence of the judiciary and prevent the courts from being an arena for settling scores and abuse of judicial time and resources. We've also similarly noted a disturbing trend at the Public Service Commission, which under Article 232 of the Constitution is required to ensure transparency and provision to the public of timely, accurate information, as well as ensure fair competition and merit on how evictions are to be carried out. The courts have also delivered several decisions on the manner of carrying out evictions. The roadside declarations by the Deputy President cannot therefore substitute the law, and we urge the Deputy President to withdraw his remarks and uphold the rule of law and the Constitution, which he took an oath to protect. The Law Society also wishes to point out to members of the public that the courts have stayed the establishment of the office of the Chief Administrative Secretary. Therefore, unless the court orders are vacated, both the government and the public should refrain from participating in any actions in breach of the court order. We remind the public that in giving ourselves the Constitution, we resolved to have the rule of law and fidelity to the Constitution as our constant true north. At all costs, otherwise we invite anarchy and chaos. Ladies and gentlemen, that marks the end of our statement. We can take any questions.
From this end,
yes.
Come up with any understanding. Now, in regard to the DPP issue of the cases, I remember the one on Dr. Chumo, what you call Kenya Power case. His argument was that, first of all, he had written several letters to the DCI requesting them to see the gaps in the case. Then number two, regarding the investigating officer, that equally was supposed to submit or rather give witness statement which he wrote. In such an instance, what was he supposed to do? Now you're tied. Now you're tied.
The question then would be, how did they arrive at the decision to charge the former MD of Kenya Power if they had such gaps in their evidence? Are they saying that what has changed? The question is, what has changed in that situation? By the time they were making the decision to charge him, they must have known of the gaps. And I think that is the explanation that he must give the country. Was it a political decision, or was it a decision that was based on the evidence that was placed before him at that particular time? If it is a question of discovery of